Rules Committee come to order, and good evening. The Rules Committee tonight will begin its hearing with H.R. 3192, the Homebuyer Assistance Act. H.R. 3192 would provide a temporary safe harbor until February of 2016 from enforcement of the Consumer Financial Protection Bureau's rule to streamline disclosure requirements for consumers. This bill would merely provide a period to allow stakeholders to gather information about implementation and provide guidance to address implementation changes. In other words, ready, aim, fire instead of ready, fire, aim. With us today, we have two very important people, some of my favorites in this Congress, from the Financial Services Committee, my home of now 18 years, where I have all, yes, this is true, You'd forgotten I used to serve there back with Jim Leach. I know I see that smile. Okay, you remember I was that guy down the front row that everybody used to throw their spitballs at? Tonight we have, obviously, Ranking Member Waters and the young chairman of the committee, Jeb Henschling from Dallas, Texas, from the Financial Services Committee. And so I know that tonight will be a good opportunity for us to hear a clear delineation of not only why we're here, but what's important to consumers and people in financial services to make things better for our country. I'd like to yield, if I can, first to this dapper young woman who got her hair done over the weekend.
You should all be grateful.
The gentlewoman Ms. Slaughter's recognized.
Look how pretty it is. All cleaned up.
I took a shower.
No statement, thank you.
No statement.
I just can't wait to get into this great discussion. Why? Because I just love the title, Homeowners Assistant. And I can see somebody saying, let's assist all these homeowners by taking away their right of legal action for a year or two while we do our great harm out here. And I hope everybody knows about Bernanke's book about all those bankers who should have gone to jail. Why he didn't say so at the time, I don't know. But he's got his book out now, his memoir. But anyway, this is going to be good, Mr. Henschling. I'm desperate to hear how you're going to help those homeowners.
Thank you very much. The gentlewoman yields back her time. By the way, a lot of this comes from the hours that we spend with each other. And I will tell you that we really appreciate both of you being here today. It gives us an opportunity to hear directly from you about the important things that not only the Financial Services Committee is doing, but also this Congress. And with that said, I would remind both of you that our awesome stenographer would like for you to speak well into your microphone. It's also easier for us to hear, but if you have anything in writing that you choose to leave, she would sure appreciate it. With that said, the chairman, the Fighting Texas Aggie from Dallas, Texas, Chairman Henschling, is recognized.
Thank you, Chairman Sessions and Ranking Member Slaughter, members of the Rules Committee. Thank you for the opportunity to testify on H.R. 3192, a bill approved by the Financial Services Committee by a very strong bipartisan vote. The bill is narrowly focused. It is a modest effort to help home buyers avoid disruptions when closing on their home as a result of the new rule issued by the CFPB, the Consumer Financial Protection Bureau, which became effective October 3rd, 72 hours ago. H.R. 3192 is the Home Buyers Assistance Act. It is sponsored by our Republican colleague from Arkansas, Mr. Hill, and co-sponsored by our Democratic colleague from California, Mr. Sherman, both of whom are distinguished members of our committee. H.R. 3192 provides a temporary, I repeat, temporary 4-month safe harbor from enforcement of the CFPB's new TILA-RESPA integrated disclosure rule known as TRID. Yes, we do have lots of acronyms in the federal city. Provided that those subject to the rule make a good faith effort to comply with it. The bill does not alter the substantive provisions of the CFPB's rule, nor does it delay the effective date of the rule in any way. Also, it does not protect bad actors. As I mentioned, to qualify for the safe harbor, a market participant must make a good faith effort to comply with the rule. Prior to Dodd-Frank, Congress passed the Truth in Lending Act, or TILA, and the Real Estate Settlement Procedures Act, or RESPA, to ensure prospective home buyers have adequate information about the cost associated with purchasing a home. TILA helps mortgage applicants understand the cost of mortgage credit. RESPA helps homebuyers understand settlement cost. Traditionally, the Fed, the Federal Reserve, implemented TILA, and HUD, Housing and Urban Development, implemented RESPA. Each agency required different yet duplicate disclosure forms for homebuyers. Dodd-Frank transferred rulemaking authority for TILA and RESPA to the CFPB and charged it with simplifying these forms, hence CFPB's new TILA-RESPA integrated disclosure, also known as TRID. Now, there is very little about Dodd-Frank with which I agree, but there are some provisions that I do agree with, and reducing duplicative bureaucratic requirements is a good idea in Dodd-Frank. In this case, turning 4 duplicative disclosure forms into 2 streamlined forms clearly benefits consumers. However, the CFPB's new rule, which I brought with me today, weighs in at 1,888 pages. If you were to read 1 page every minute, which means you're probably a faster reader than me, it would take you over 30 hours to get through the document. So again, 1,888 pages of rules to go with 2 streamlined forms. In order to comply with the TRID rule, market participants have invested millions of dollars in new software and hundreds of thousands of hours in new training for employees. By and large, they are successfully coming into compliance with the rule. However, as with any significant change, there is a risk that mistakes will be made during the initial implementation phase. The new rule became effective again on Saturday, meaning that it applies to all new mortgage applications submitted on or after that date. If there is any type of glitch in satisfying the new rule, it will not likely be felt until 4 to 6 weeks from now when home buyers are trying to close on their new homes. And a glitch risks delaying that process, costing money, and creating stress for home buyers, and potentially actually torpedoing the home buying process. Buying a home is stressful enough. I sincerely hope that none of my constituents encounter problems buying a home as a result of this CFPB rule. However, the risk that could happen is precisely why an overwhelming bipartisan majority of the House has sought a formal hold harmless period during which market participants making good faith efforts to comply with the rule would be spared from enforcement actions from the CFPB or private lawsuits brought by trial attorneys for technical violations of the law. On May 20th, for instance, 255 members of the House, including 11 of 13 members of the Rules Committee, wrote to CFPB Director Cordray explaining, quote, as the TRID regulation does not provide lenders an opportunity to start using the new disclosure form prior to the implementation date, market participants will not be able to test their systems and procedures ahead of time, which increases the risk of unanticipated disruptions. The signatories therefore sought, quote, a grace period for those seeking to comply in good faith through the end of 2015. Having this grace period is vitally important because it provides assurance to the market that companies can make full use of these new forms without undue legal risk. This is good for consumers. The key, however, is that the grace period be formally announced and that the length of the period be specified. Otherwise, businesses are deprived of the certainty necessary for making good decisions going forward. Regrettably, despite multiple opportunities, Director Cordray has refused to announce any type of formal grace period for compliance with the TRID rule. The most he'll commit to is that he will, quote, be quote-unquote sensitive and quote-unquote diagnostic regarding his assessment of efforts to comply with the rule. When specifically asked at a recent hearing before our committee whether market participants could count on him not to bring an enforcement action for a period of 6 months, Director Cordray said that market participants would have to, quote, read between the lines, unquote. So much for clarity and certainty for both consumers and industry. Announcing a hold harmless or grace period costs Director Cordray nothing but provides a great benefit to home buying consumers and market participants alike. It also spares Congress the time and effort of enacting a bill to do what any prudent and accountable CFPB director should want to do as a matter of course, and yet here we are. The ranking member is fond of saying that the CFPB director is accountable to Congress. If so, once again, a letter signed by 255 members of the House, and I believe it was almost 40 members of the Senate, and in the House, including 22 Democrats on the Financial Services Committee, and I believe the ranking member of the Rules Committee all signed on to this letter, so it is challenging to figure out how the CFPB director is being accountable to Congress at this time. And so his failure to make even a modest accommodation to satisfy the collective request of well over half, approaching 2/3 of the United States House, would suggest emphatically that he is not accountable. H.R. 3192 passed out of our committee 45-13. Almost 80% of the committee supported it. Roughly half the Democrats on the committee supported it. Frankly, it should be on the suspension calendar. I regret we're having to take up the valuable time of the Rules Committee to discuss this. Nevertheless, I do appreciate the opportunity to testify before you today, and as always, and hope we can work together to provide greater certainty to our home buying constituents in the weeks ahead when this very complex rule for the first time is allowed to go live. I welcome your questions, and again, thank you for this opportunity.
Thank you, Mr. Chairman, Ranking Member Slaughter, and committee members for allowing me to speak today on H.R. 3192 for the Homebuyers Assistance Act. For decades, federal law has required lenders to provide two different disclosure forms to consumers applying for a mortgage. The law has generally required two different forms shortly before closing on the loan. Recognizing the opportunity to streamline these disclosures and improve customer understanding, Dodd-Frank tasked the Consumer Financial Protection Bureau with reconciling these dual disclosures traditionally required under the Truth in Lending Act and the Real Estate Settlement Procedures Act. H.R. 3192 would require by law a safe harbor period for lenders until February 2016 by preventing regulators from enforcing the new disclosure rules as long as lenders make good faith efforts to comply with the law. First, allow me to note that I'm not concerned about this provision of the bill, since regulators have already indicated that they will take good faith efforts into account, and current law already provides good faith allowances for lender errors under TILA. Therefore, I understand why members would want to create additional certainty by codifying this forbearance. However, as the bill is written, H.R. 3192 would go further by suspending existing consumer rights under the Truth in Lending Act by preventing borrowers from even filing suit against lenders who produce misleading disclosures. The practical effect of H.R. 3192, if it is not amended, would be that borrower suits against lenders will be dismissed outright if undefined good faith errors committed by lenders occur in the next 5 months, even if borrowers relied on inaccurate or misleading disclosures. The inability to even have a case considered could be devastating to consumers who are making one of the largest financial commitments of their lifetimes, even if the error in question were committed in good faith. Notably, H.R. 3192 would permanently bar any suits for violations that would occur between the enactment of H.R. 3192 and February 2nd, 2016, if the violation is in good faith. Consumers are in no position to determine if an error constitutes a good faith violation of TILA, and H.R. 3192 departs from current law by unfairly placing the burden on consumers to prove that an error was not made in good faith, a virtually impossible bar for consumers to clear. To be clear, my opposition to 3192 is only concerned with the suspension of a consumer's ability to meaningfully have their day in court should a lender fail to properly disclose the relevant terms of the new TILA RESPA disclosures. I fully support the temporary hold harmless period for CFPB enforcement And with Congresswoman Maloney, I helped to lead efforts to ask the CFPB to consider a formal hold harmless period with many of my Democratic colleagues from the Financial Services Committee. I likewise applaud the Federal Financial Institutions Examination Council's recent announcement that examiners will undertake a similar period of restrained supervision, consistent with my support for restrained administrative enforcement and my concerns about H.R. 3192's suspension of consumers' private right of action under TILA. I have drafted an amendment that would restore the private right of action under TILA, but that leaves the rest of H.R. 3192 in place. I believe that this approach strikes the proper balance of protecting a vital consumer protection while also giving lenders and other service providers the time they need to ensure that their processes for generating the integrated TILA RESPA disclosures comply with the CFPB's new rules. So, Mr. Chairman, I join a broad coalition of civil rights groups and consumer advocates in voicing my concerns regarding H.R. 3192's suspension of existing consumer protection, even for a temporary period. Private enforcement serves two vital purposes. First, private liability helps to ensure that consumers can protect themselves and their investment should a lender fail to make the proper disclosures under TILA. Second, the possibility of private liability provides strong incentives for lenders to comply with the CFPB's new rules in a timely fashion, as much of the industry has already managed to do. Today, I've offered an amendment that remedies the suspension of the private right of action during this period, and I believe that my amendment preserves the CFPB's cooperation with industry to date while also maintaining an important consumer protection. Again, I thank you for allowing me to speak before you today, and I would just like to say this, that I have from day one said that, of course, Dodd-Frank is the law of the land, and I feel a responsibility to join with those who understand that we have to implement Dodd-Frank. However, I have also said that I'm not opposed to technical corrections and some limited modifications that may be appropriate at times like this. And so I want you to be clear that I have supported the CFPB, and the CFPB and Mr. Cordray have been very cooperative in saying to the industry, I understand your concerns, and I will not implement any enforcement for well into next year on this legislation. He's committed to that, and he said that over and over again. And the only place that I am voicing my concerns is on the suspension of existing consumer protections, even for a temporary period. I don't think any member of Congress want to say to a private citizen, you don't have the right, if you see that and feel that you have been harmed, to go into court on a private right of action. And this should not in any way keep us from getting together and coming together around this legislation that will do the most important thing that the industry have asked for, that we have agreed to. You need the time in order to, get your house in order. And Mr. Cordray has said, I support that. I've said I support that. Why can't we get together just on this one portion of the bill that deals with the private right of action for our consumers and our citizens? I'll yield back the balance of my time.
Thank you very much. New rules and regulations.
That's correct, Mr. Chairman.
And you're bringing this information today to us and saying, we've tried to work, we want to work to make sure that we receive a period of time so that people who are doing the work all across this country know what they're supposed to do do it correctly, good faith effort, and they're going to be all right under this law.
Well, if I could, Mr. Chairman, again, there is a underlying good idea here, and that is to streamline disclosures for consumers. It's a very important mission that we have in Congress, and it's an important mission of the CFPB. However, the CFPB, on their very complicated, complex 1,888-page rule, has not allowed those in the industry who provide mortgage financing for low and moderate and our income people and constituents trying to buy homes, have not even allowed them to have a trial run. So they essentially had to go live on October 3rd. They couldn't have previewed this. They couldn't have tested out their new software systems. They couldn't have tested out their training. So it's not just the complexity, but the CFPB prohibited anybody from using the new forms until October 3rd. And so again, we want to make sure that the bad actors are fined or prosecuted under the full extent of the law, but we're simply saying on something that is this dramatic, this complex, that could harm the potential homeowner, who I think is probably more interested in buying a home than they are in a lawsuit. You know, for 4 months, frankly, it's now 4 months minus 3 days, the way the bill is written, just hold harmless those who actually act in good faith for a short period of time as we try to integrate this incredibly complex, complicated rule into the system. Otherwise, what you're going to have, Chairman Sessions, is you're going to have mortgage lenders who are going to hesitate to make these mortgages. Already I've heard from a number of people in the industry from home back in the Lone Star State. I've heard from a title agent in Tyler, Texas, not too far from where you and I live in Dallas. He said, quote, "Due to no fault of the small and regional lenders, the LOS software they have paid for is not ready. Many lenders just got their software and are just now this week getting training on their software. They are left with the quandary of giving a loan estimate, which might result in the consumer getting inaccurate information or just turning down the loan. Large lenders have already announced they're not going to make one-time closings anymore due to the uncertainty." I heard from another title agent in Austin, Texas, who said, quote, "No question more conservative lending and sales volumes will result. This will impact both buyers and sellers." He also added that the new rules without the safe harbor vision, quote, "could have a cost impact. Lenders may decide to raise fees to cover potential exposure." In that, with any uncertainty, lenders will continue to be overly cautious and default to the most conservative course. Finally, one based in El Paso said at least one lender at a TRID workshop was going to stop residential mortgage lending for a time until they could get a good feeling on how the regulations were going to be officially interpreted. So that's the real live reaction, Mr. Chairman, in the marketplace, and that's why it's so critical if we want people to have the ability to close on their homes, that for a very temporary period of time, 4 months, if you're acting in good faith, you ought to have a little time to implement this complex rule. I remember Obamacare was on the books for a lot longer than the TRID rule has been on the books, and yet that rollout got botched up. I don't recall anybody being successfully sued for that one. So let's give a break to those who want to buy their homes.
Mr. Chairman, I couldn't agree more. People that want to play by the rules want to make sure they're doing so properly and to do their best, not only their best effort, but to represent the consumer too, and that is their job. I want to thank you very much for being here today, both of you, but Mr. Chairman, thank you for bringing not only your words, but also the bill to remind us of the daunting task that is faced by people who receive mandates, and they got to follow the law, and they want to, but they just need a little bit of help getting there, and thank you very much. Mrs. Fox.
Thank you, Mr. Chairman, and I want to thank our colleagues for being here. I think we probably need to more often show graphically what the rules are from these various agencies, and so I really appreciate the chairman bringing the rule for simplifying the form. We had the good fortune this week, I hope, of selling a house. And I went by to sign the papers yesterday, and the young woman working in the lawyer's office said, please, please do something about Dodd-Frank and all the new rules that are out there. She didn't mention CFPB, but I know what she's talking about in terms of how it's driving us crazy in these offices. I take the position that we are killing ourselves with rules in this country, absolutely killing ourselves. We'll never stop bad behavior. The Lord's been trying to do that since he sent down the 10 Commandments to Moses, and it hasn't worked. What we should be doing is, instead of tying ourselves and all these other people up with this kind of ridiculous situation, is to punish the hell out of people who break the rules. Make the rules as simple as possible, and you break them, you get punished. But we don't do that anymore. We simply try to prevent any kind of bad behavior, and just isn't going to happen. Mrs. Waters, you know I like you a lot. We're friends. But when you said, Mr. Cordray said they won't enforce the rules, then why'd you put it in place to begin with? And it reminds me of somebody saying, if you like your health care plan, you can keep your health care plan. And every time we hear a promise from somebody like Mr. Cordray, that's what keeps coming back to my mind. And we know how long that lasted. So, I mean, I'd be looking to sell some swampland in Mexico if I believed every bureaucrat who made those kinds of promises. So thank you very much both for being here. Thank you, Mr. Chairman, for bringing the legislation. I support it. I yield back.
Gentlewoman yields back her time. The gentlewoman from New York.
Thank you very much,
Yes,
Mr.
ma'am.
Chairman. Let me yield to Ms. Waters. I think I noticed you were waving frantically there to try to.
Thank you so very much. And I think what I'm going to share with you is appropriate given Ms. Fox's information that she shared with us about Dodd-Frank. In the Wall Street Journal this weekend, the Independent Community Bankers Association, that is ICBA, President and CEO Camden Fine affirmed this. This is what he said. Dodd-Frank, that term became the poster child for every regulatory ill that's been fostered into community banks, said Camden Fine, president of the Independent Community Bankers of America, which represents thousands of small banks. There are regulatory burdens that community banks face today that are real, but had nothing to do with Dodd-Frank, he said. Dave Stevens, head of the Mortgage Bankers Association, told NPR about the rule going into effect over the weekend of October 3rd that, and I quote, "I'm optimistic that this will be implemented in a way that allows transactions to occur. It's not going to be a train wreck and ultimately is good for the consumers." So I just share that with you because even though the lady who talked with you when you were trying to do your closing referred to Dodd-Frank in general, we have a lot of that going on. And here you have bankers saying, pay no attention to that. They don't know what they're talking about. I yield back the balance of my time.
Well, thank you. I want to thank both of you for being here. And I just repeat what I said at the beginning. Whenever I see something that Ms. Fox is saying, what always throws her, it's the title of bills that I really enjoy. And this one is the Home Buyers Assistance Act. And what you're doing is really taking away their right of action. And I agree with Ms. Waters. I think it's time it went into effect. And if the bankers don't mind, I don't know why the House of Representatives is making such a to-do about it. I yield back the balance of my time.
Gentlewoman yields back her time. The gentleman from Louisville, Texas, Dr. Michael Burgess.
Thank you, Mr. Chairman, and thanks to our witnesses for being here. As I sit here and listen to the discussion back and forth, Chairman Hensling, I agree with you. I don't know why this wasn't handled as a suspension on the floor of the House. Just like Ms. Fox, I have some anecdotal data that I could share with you about a family member who works in a real estate closing office, and they are looking at, I was informed last week, they were looking at significant layoffs in their office because they didn't know what the ground ahead, it seemed uneven to them. I didn't exactly understand to what they were referring as we sit here and discuss this bill now. I understand the rule that went into effect a week ago Saturday is probably causing that unease. Look, if the real estate market has had its ups and downs, and we all know people who have been affected by it, if there is something we can do to perhaps make the process a little less daunting, and we're not talking about suspending the regulation, we're simply talking about suspending the enforcement period until people find out what this rule actually means to them. I think that's a reasonable approach, and Mr. Chairman, then I'll be happy to support the rule and the bill on the floor. And I'll yield back.
Thank you very much, Dr. Burgess. Gentleman from Massachusetts.
No, I appreciate you both being here. I will associate myself with the remarks of our ranking member and Ms. Waters, and I have no questions, and I yield back.
Gentleman yields back. Son, the gentleman from who doubles with the Financial Services Committee, the gentleman from Ohio, Mr. Stivers recognized.
Thank you, Mr. Chairman, and
Yes,
this is a timely hearing. I was in a real estate office yesterday in Chillicothe, Ohio, in Carnes Realty, just taking a tour of their new office and talking to them, and they were very concerned about this rule and making sure that there was a chance for folks who do things in good faith with the massive new regulation not being, held liable. And I will tell you on the regulation, there's a couple things I'm really concerned about, and we didn't get into the details of it. But in Ohio, at a closing in Ohio, the check you write for title insurance when you buy a house will now, for the first time, not match the disclosure. The amount they put is different than the check you write. That's wrong. I've talked to Richard Cordray about it. It will make people think they're being taken advantage of. It will make people think there's something wrong. And, what they have said is Ohio needs to change its law and change the way they calculate it. That's going to raise rates for people in Ohio. And I don't think that's right either. And so I've pushed back on that piece of it. The other piece I'm really concerned about in the regulation is the way it's written today. If there's a material change in the terms, you have to delay the closing for 3 days, even if those terms change in favor of the borrower. What? I understand if it changes to the detriment of the borrower, you may need to take a step back, take a deep breath, say, do you still want to do this? But and I've talked to Rich Cordray about that, and they admit that's a drafting error. I hope they fix it. But that's the point. It's 1,800 pages, Mr. Chairman. I'm glad you brought it because it's massive. And it's a big change for a lot of people, and that they need some time to adjust to that change. And the big fight appears to be, it appears we all can hold hands and sing Kumbaya about delaying the enforcement for a little while. Even the ranking member agreed to that piece. She seems to have a concern about the term good faith. Mr. Chairman, is good faith easy to understand, whether somebody complied with something in good faith, or is it hard to understand?
Well, I had a brief and unremarkable legal career earlier in my life, but I do remember studying the concept of good faith, which is a well-established legal doctrine with a lot of case law behind it. If I could, though, one, thank you for your service on our committee. The gentleman from Ohio is an outstanding workhorse on our committee. But with respect to a safe harbor, if you take out the barracuda from the harbor and you leave the sharks, it's still not a safe harbor. And so to say that, well, the CFPB may or may not bring an enforcement action, but to believe private litigation, then you don't have a safe harbor. Either you have a safe harbor for a temporary period of time, you don't have a safe harbor for a period of time. And so, again, huge bipartisan majority of the House has signed a letter saying there ought to be a safe harbor. I thought people knew what they were signing when they signed the letter. Perhaps they didn't, but anyway, I thank the gentleman for the question.
Well, a week ago at the hearing, Mr. Chairman, to follow up, Director Cordray, who happens to live in my district, was asked by Andy Barr about delaying the TRID rules and whether he would be willing to delay them till the end of the year. And I will read what the Director Cordray said, and you tell me if he's going to delay any kind of punitive action. look, I don't think it's appropriate for me to say I won't enforce the law when my job is to enforce the law. But I think I've said to them that we're going to have a diagnostic and corrective, not punitive, approach in that early period. I think if they read between the lines, this is what he wants them to do, read between the lines, they will understand that I'm trying to allow them to have the latitude for what they've asked for. I think people should take yes for an answer. But it's not really yes for an answer. It's a very cloudy, murky answer. It's we might, do this, but we can't say we won't do any enforcements, even if somebody acted in good faith. Do you read it the same way? Did you hear
Well,
that
absolutely, I
the same way
read it the same way. And as for example, look at this piece of printed material. Between the lines is blank space. I derive nothing from blank space. I take no comfort from I'm supposed to have some type of epiphany by looking at blank space between the lines. That does not tell me what Mr. Cordray intends to do. And I know the ranking member takes great comfort from his words, in which case, at worst, the legislation before us is merely going to be redundant. If that's the worst sin of a piece of legislation that has in overwhelming bipartisan support on the committee, 80% of our members support it, overwhelming support in the House, 255 members, including 91 Democrats. If redundancy is the worst we can do, why don't we go out and pass this bill?
Well, I think that's right. And Mr. Chairman, on October 1st, just 2 days later, let me read something that Director Cordray wrote after that to a bunch of trade groups who asked for a hold harmless period. He said to them, during initial examinations for compliance with the rule, the agency's examiners will evaluate an institution's compliant management system and overall efforts to come into compliance, recognizing the scope and scale of changes necessary for each supervised institution to achieve effective compliance. Does that sound like a hold harmless period?
Didn't sound like one to me.
That's why I think we need this bill. And, I recognize there may be some differences of opinion, but I think it's really important for folks in the field to understand that we aren't going to, clamp down on them when they haven't even had a chance to understand completely the regulation. Yes?
This conversation continues to go on about whether or not Mr. Cordray supports a hold harmless period. We all agree to that.
But did he?
But no one, oh, absolutely, and he spoke to it. But what you are failing to talk about is the private right of action under TILA. I don't hear any real discussion about whether or not you support consumers. The good faith language still leaves consumers vulnerable to cases on the margins and shifts the burden of proof unfairly to consumers. My Republican colleagues here contend that the good faith allowance in 3192 provides adequate redress in the event that a consumer seeks to bring an action on the Truth in Lending Act. The good faith language would allow consumers to bring actions if there are clear violations of Truth in Lending Act, but in less clear cases, a regulated entity would simply need to demonstrate that they made an effort to comply with the new rules, even if a consumer relied on inaccurate, misleading, or untimely disclosures to their detriment. Current law does not require that borrowers first make a determination that an error be made in good faith before they can file an action under Truth in Lending Act. They can simply file an action if they believe that a lender violated Truth in Lending Act. If adopted, 3192 would shift the burden of proof to consumers to determine if an error is made in good faith, a bar that is difficult for consumers to determine when an action is filed. H.R. 3192 is a harmful departure from existing law that erodes existing consumer protection. So we agree that there should be this hold harmless period. Mr. Cordray agrees. He will not do enforcement. I'm trying to get your attention on the consumer and their right of a private right of action under TILA, and that's only under circumstances where they really do believe they have been harmed.
Well, let's talk about that, Mr. Chairman. Do you believe we should have consistent enforcement standards under one regulatory body, or multiple courts throughout the country enforcing standards the way individual judges perceive them.
No, I certainly believe that one standard that creates greater certainty for the home buyer and for the mortgage lender is certainly what is preferable here. But with all due respect to the ranking member, I think she's setting up a false choice. To me, the choice is, do you come down on the side of trial attorneys or do you come down on the side of home buyers? And I think that any home buyer that I speak to in the 5th District of Texas, when told there is a 1,888-page new rule that's standing between you and the American dream, and for a little less than 120 days, we want to say that people operating in good faith can help you close that home. My guess is most of them will say, you know what, I would rather have the home than the lawsuit. And again, I go back to the proposition. If we're going to have 1,888-page rule, and if we believe there's a safe harbor, either it's a safe harbor or it's not a safe harbor. Being a safe harbor from the CFPB, which is still murky, we don't know because we have to, quote unquote, read between the lines. So the ranking member is quite confident about what she sees between the lines. I'm not sure those in the marketplace, and certainly I'm not too confident at what I see in between the lines. But setting that aside, to say that the CFPB would show forbearance, and yet there comes class action suits galore, again, there was a botched rollout of Obamacare, and they had many more years to plan for it. CFPB botched their own rollout because they violated the law because they didn't comply with the Congressional Review Act. They had to reel the whole thing in before they could set it back out. Where's the lawsuits against CFPB for that? Who's being fined at the CFPB? Again, it goes to a double standard here. And we know that government has made mistakes. And I assume Mr. Cordray was acting in good faith, but they made a mistake and they violated the law. But there were no repercussions to him personally. There were no repercussions to the CFPB. And so if we want to be able to make sure we don't disrupt the home buying process, this is so modest, so reasonable, which is, again, why 255 members of the House have asked for it. It's why 41 members of the Senate have asked for it. It's why it has one of the strongest bipartisan bills that we have seen. And again, I don't even understand why we're taking up the time when it should have been on the suspension calendar.
Thank you, Mr. Chairman. I yield back, Mr. Chairman.
Thank you very much. I appreciate the gentleman very much from
Thank you, Mr. Chairman, and thank you both for being here to explain. We have not, at least most of us, have not had the benefit of sitting through the committee and learning all the details about this 1,800-page bill, or regulations. So I appreciate getting a little bit of information about it. I would submit that not only consumers and industry participants, but others that might benefit from a grace period to comply would be those that are tasked with enforcing this rule. As a former agency director myself, I know that rules can be complicated on both sides of the enforcement equation. And so taking the time to get it right, having a grace period for everybody to figure out what's going on, seems to me would be a good idea. But I want to get back just a little bit, if I could, to the point Ms. Waters raises about consumer protection, I guess is the topic that and so just I'm not an attorney, not on the committee, just a simple question: does suspending or putting in place this time period take away consumers' protection? Does it suspend their ability to have their day in court, as Ms. Waters says? And I'd like a response from both of you, if you could give that.
Well, first of all, I think we need to reiterate and say over and over again that we all agree on a grace period. And while my chairman keeps talking about the importance of having a grace period, and it's being raised whether or not this benefits the consumers, this benefits the business community, this benefits the regulators, yes, a grace period is what we all agree on. I support it. Mr. Cordray supports it. Mr. Cordray has said publicly over and over again, there will be no reinforcement for a period of time. And so let's take that off the table. We agree on that. What most members have not had the opportunity to focus on is if there is an overt, outright undermining of the law that says you must do certain things, you must have certain disclosures. If someone just decides, I can use this period of time to get away with not having to do what I should be doing to inform consumers about, you know, what this mortgage is all about, I'll just use this period of time to do it, and I don't have to worry about it because the member of Congress have taken away my right as a consumer to go in court and challenge this. That's what that's about. We are in the legislation taking away the consumer's private right of action, even in the face of all the violations that would take place by someone who's taken advantage of this consumer. So let's have a grace period, but let's not take away the consumer the right, private right of action to say, oh my goodness, this lender has gone far too far and has denied me of the basic rights that I should have with disclosure, et cetera. And I'm gonna go and I'm gonna, use my private right of action to say to the court, look what's happened to me on the most important thing that's gonna happen in my life, the purchase of a home. That's all it's about. Let's take off the table this grace period. I agree to that. It's the private right of action that I have a problem with.
Mr. Chairman, what say you?
Well, I believe that what the ranking member said, part of it is just factually incorrect. The right of private action still exists. Homeowners can still bring private suits, but there is a good faith exception. So for bad actors who purposely violate the law, who knowingly violate the law, who violate the law with malice aforethought, can still be held accountable in a private right of action. The underlying bill does not preclude that. It has a good faith exception for those who are attempting to comply with the law and acting in good faith. And yes, that becomes a legal question, whether or not one operated in good faith. And that is something that would be settled by the courts. But it is not factual to say that the bill takes away a private right of action. I wanted to clarify that, and I don't know how we can continue to clarify what Mr. Cordray hadn't clarified. Reading between the lines is not a clarification. Period, paragraph. Thank you.
Mr. Newhouse, would you yield to me just to elaborate on that for a moment? Thank you very much. I appreciate it. If during this period of not enforcing the law, what right of action does the consumer have?
Well, again, the law will be enforced. There is merely a good faith exception. If one doesn't operate in good faith, as I said earlier, if one knowingly violates the law, if one purposely violates the law, they don't have access to a good faith exception.
Is there some financial benefit to the consumer that the law is in place at the time that they want to bring the right of action? Or I'm assuming what you're saying is that as a citizen, they have a right to bring action if they want to, but they are facing a penalty that's not in effect, correct?
I'm sorry, I'm sorry, I didn't understand the latter part of the question.
During the grace period, as I understand what Mr. Cordery said, is that they will not do anything to enforce this provision. So
that is not my understanding.
It is my understanding.
I thought you read that,
I
right?
did.
That's the way I heard it, but we won't get into all that because our job is just to put the bill on the floor. But I do believe that there could be a question as whether the consumer could literally have a right of action when this section is not enforced.
Will the gentleman?
But I'm not a lawyer either. I'm a microbiologist, so.
A microbiologist?
I could discuss the germ theory of disease on it, but I guess it wouldn't apply. Thanks.
Will the gentleman?
You're welcome. Please continue.
Thank you. If in fact the chairman believes that the citizen's right to go to court are not in any way diminished in this legislation, let's just make sure. My amendment would do that. And if you are concerned about the consumers and you believe that they are already protected, and I believe that they are not protected, let's take away the uncertainty and let's take the amendment, and that way we will both be on the side of the consumers.
Mr. Chairman, reclaiming my time, it seems to me that this is a simple one-page clarification to temporarily give a safe harbor to people involved in these transactions. There are some things that we could perhaps assume could happen, but it's black and white. It seems to me that it's pretty clear. And with that, I'll yield back my time, but appreciate the delving into the details of this conversation.
Thank you very much, gentleman. Yields back his time. Am I looking for anybody else that would seek time? Seeing none. I want to thank both of you for taking your time today. I know this is important. One thing I did not mention, I know Louise did not mention, but all of us in this body recognize, and I waited till everybody was here, but we recognize the good people of South Carolina have been harmed greatly. And I had a meeting today that we discussed this national tragedy because we're not all impacted, but we all need the help. We all do care. And I wanted to specifically say that I had a conversation this afternoon where I put us all on record that we would be there to discuss this and make ourselves available if at any time it became important for the Rules Committee to meet, for us to get anything to the floor that would be necessary. And so I wanted to make sure all the members knew. I did speak for all of us, and I felt like you'd go along with that too, but we're good people. I feel sorry for them. Thank you very much, Chairman Henserling. Ms. Waters, thank you very much. And if you'll please make sure you leave anything you've got for our great stenographer. Yes, seeing Governor Haley this weekend over and over and over dealing with this and the people, it struck me a lot. Okay, this closes the hearing portion of H.R. 3192. The chairman would now welcome the next committee. Next committee will hold an original jurisdiction legislation hearing and markup of a House resolution to establish a select investigative panel of the Committee on Energy and Commerce. This draft resolution authorizes the creation of a select investigative panel of the Energy and Commerce Committee comprised of 13 members appointed by the Speaker, 5 of whom will be appointed on the recommendation of the minority leader. The resolution requires the panel to conduct an investigation and study and issue a final report of its findings regarding medical procedures and business practices used by entities involved in fetal tissue procurement and other relevant matters with respect to fetal tissue procurement, federal funding and support for abortion providers, practices of providers of second and third trimester abortions, including partial birth abortion and procedures that may lead to a child born alive as a result of an attempted abortion, medical procedures for the care of a child born alive as a result of an attempted abortion, and any changes in law or regulation necessary as a result of any findings resulting from the investigation and the study. Today we have testifying on this issue 2 members of Congress from the Energy and Commerce Committee that will be specifically empowered to be here today to talk about this. They include my dear friend, Congresswoman Marsha Blackburn from Tennessee, and also my friend from New Jersey, Mr. Pallone. Frank, good to see you today. Marsha, glad you're here. And before we proceed further, I would allow the gentlewoman, if she would choose to make any statement, the ranking member, the gentlewoman's recognized.
Thank you, Mr. Chairman. Thank you both for being here and for your hard work. And I do thank you for yielding me this time. It's important to me. From the outset, the Democrats in the House have bemoaned the creation of the Select Committee on Benghazi. We knew from the beginning that the committee, which has already spent $5 million on duplicative investigations of a non-existent scandal, would be used to politicize that tragedy. What we didn't know is that the majority would ever admit to it, and then last week, House Speaker in waiting Kevin McCarthy accidentally told the truth on television and revealed what we knew all along, that the Select Committee on Benghazi was for political purposes. He told all of us with the camera rolling that the Select Committee was used and intended to undermine the electoral process and one candidate in particular, and that abuse is wrong. That Select Committee has spent about $5 million of tax money on politics, not governance, that is against our oath of office, and it is a disgrace. That $5 million of official money has been expressly used for campaign reasons, following all the other committees on this same thing, all of which came up with with the exception, I think, maybe of Chairman Issa, who came up with no conclusion that I know of, that there was nothing there. Also, 3 committees in the Senate decided the same thing as the state. Now, Congressman McCarthy was clear. Select committees have been used for purely political purposes, and this new Select Committee on Planned Parenthood will be no different. Creating a Select Committee to investigate Planned Parenthood will do nothing. Congressman Chaffetz himself, who berated Planned Parenthood CEO Cecile Richards for 5 hours last week, was asked by CNN's Wolf Blitzer, and I quote, "Is there any evidence, in your opinion, that Planned Parenthood has broken any law?" End quote. Mr. Chaffetz responded, quote, "No, I'm not suggesting they broke the law," end quote. If they haven't broken any law, why would you spend 3 or 4 more millions of dollars in a Congress that has no budget, is facing yet the shutdown, absolutely no political legislative record to speak of, and continue to go after this organization over 100 years old that is giving health care to a large number of women in the country? The records I understand are 1 in 5 women in America have taken advantage of Planned Parenthood services. Why would we spend the time and the funds and the resources investigating an organization that we all know has done nothing wrong? We know that not a dime of federal money ever goes into abortions, not a dime. And that's been proven over and over and over again. I can remember other hearings and other Congresses trying to do the same thing. But this is another example of a majority obsessed with another useless Select Committee, and they will use any tactic necessary, be it another Select Committee or intentionally misleading data. Mr. Chaffetz tried to use those tactics in his hearing last week, all of which were resoundingly discredited. His hearing materials, one chart in particular, was called by one press account, quote, things I can't even repeat. What he did, let me say, this is my own quote. The things that they were called by the press are words that I may not use here, or I would violate the rules of the House. But this is scandalous, what we're trying to do here. And I think America knows it. It's no wonder they're so, as I understand it, we have a worse reputation than cockroaches. So I will yield back with that, but I think I've certainly made my point that this is another useless exercise of brain power, staff power, everything that we do in this Congress where we hold up our hand and we swear that we're going to uphold the law. And when you start using committees of the House of Representatives for political purpose and state that it is against a presidential candidate, that's really reached a new low. I yield back the balance.
Gentlewoman yields back her time. I believe what we're doing here is very serious and very important. And I believe, excuse me just a moment, please.
Well,
Yes, ma'am.
Just say this. You had
Does the
5
gentlewoman
hours of
seek
it
time?
last week.
Does the
One
gentlewoman
woman
seek time?
sitting there
Does the
hearing-
gentlewoman seek time?
Yes, let me
The
ask you
gentlewoman's
that.
recognized.
I would almost like to ask you to raise your right hand and swear you think this is serious. You going to do that?
Yes, ma'am, I do.
All right.
Thank you very much.
You believe that with all your heart that this is a serious attempt to do something of value to the American people?
Yeah, thank you very much. We really don't question each other up here, but I appreciate the question.
All right.
So I appreciate the
Good.
gentlewoman.
I think that when all evidence is to the contrary, one must rethink one's opinion.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Thank you very much.
You're welcome.
I think, and I am not going to swear myself in, but I am bound at least
That's
by,
right, you didn't. You were down at the Republican Club while you didn't get sworn in. I'd forgotten that.
you know, I appreciate the gentlewoman very much.
Popped in.
I'm sure of that, sir. The gentlewoman was not a part of the feedback that I've received from many, many people in the 32nd Congressional District of Texas during August, June, July, and August as this issue became larger and larger. I have chosen to try and be very careful and looked for members of the committee, of Energy and Commerce Committee and others, to try and figure out what really happened. And I believe that it is important that we answer the questions, that we bring people in, and I think that's a right, an obligation, and a duty of members of Congress. So as a matter of fact, I do believe what we're doing today is very serious. I believe it is well within the jurisdiction of what we do, and I am delighted that both of you are here, and I will tell you that I think that clearing the air is very important, and that's what I hope this will be about. With that said, I'm glad both of you are here. The gentlewoman from Tennessee is recognized.
Thank you, Mr. Chairman, Ms. Slaughter, and members of the committee for allowing me the opportunity to provide an opening statement. There is no issue more deserving of our undivided attention than protecting the dignity of human life. The footage which has been released detailing abortion practices and treatment of human fetal tissue raises serious questions which deserve a thorough examination. Specifically, the select investigative panel of the Committee on Energy and Commerce will have jurisdiction to review the following. Number one, medical procedures and business practices used by entities involved in fetal tissue procurement. Number two, any other matters with respect to fetal tissue procurement. Number three, federal funding and support for abortion providers. Number four, the practices of providers of second and third trimester abortions, including partial birth abortion procedures that may lead to a child born alive as a result of an attempted abortion. Number five, medical procedures for the care of a child born alive as a result of an attempted abortion. And number six, any changes in law or regulation necessary as a result of any other findings made. I want to clearly state this is not simply an investigation of Planned Parenthood. In fact, when you read the resolution, Planned Parenthood is not even mentioned. This will be a broad-based information gathering, fact-finding mission to answer questions about how we treat and protect life in this country. The select investigative panel will centralize the investigations being conducted by the Energy and Commerce Committee, Judiciary Committee, and Oversight Committees by bringing it primarily under one umbrella. Over the past several weeks, we have been asking serious and frankly troubling questions about how infant lives are being treated. Unfortunately, our investigation has raised many more questions than we've been able to find answers. So this is a discussion that the country would like for us to have. Mr. Chairman, as you said, it is something that our constituents say we need to have a further look into these issues, and we need to have a national conversation about these practices. So this is a discussion that we cannot shy away from, nor can we step away from choosing to lead in this discussion. When baby parts are nonchalantly being picked out on pie dishes, the way a factory worker would look for the best part on an assembly line, we all need to take a step back and ask ourselves, what in the world have we come to in this country? With that, Mr. Chairman, I yield back.
Ms. Blackburn, thank you very much. Mr. Pallone, you and I both know that you and Mrs. Blackburn, as my dear friend, Mrs. Slaughter, are here talking about very difficult subjects. I appreciate, as always, your professionalism, just as I believe is trying to be displayed in here, and the gentleman's recognized.
Thank you, Mr. Chairman. I completely agree with the statements that were made by Ms. Slaughter. You know, I just am amazed by the fact that the GOP, leadership, all of you, are constantly talking about, not wasting taxpayers' money, worried about the dollar, and I think that's commendable. But I can't imagine anything that's more of a waste of time. I mean, we've had 3 committees investigating not just Planned Parenthood, as Ms. Blackburn said, but all the issues that she mentioned, but most of it by reference to Planned Parenthood for several months now. In our committee, Energy and Commerce, the O&I committee, which is set up specifically for this purpose to do oversight and investigation, has been at it for 3 months. We, the Democrats of the committee, a few weeks ago, after this intensive investigation by our O&I subcommittee, issued a report basically saying that based on all the facts and evidence that have been presented, there is no indication that Planned Parenthood specifically did anything wrong, did anything illegal. Essentially, what Mr. Chavez said, that there's been no indication of any of that. So why in the world would we set up, this bureaucracy, which you, as the GOP, rail against all the time? Why in the world would we set up this bureaucracy of a new select committee of the Energy and Commerce Committee, which already has 6 subcommittees, which already has an oversight and investigation subcommittee, and say that we're going to spend another 2 or 3 months and I don't know how much money to do the same thing that they've already done? I don't see anything in this resolution about money, so I can't really comment. My fear is that either some source of money is going to come forward, and as Ms. Slaughter said, we're going to end up spending $2 or $3 million needlessly, or even worse, in my opinion, there's no money that's being appropriated for this, which there doesn't appear to be under the resolution, in which case our committee, which has so many other things to deal with, energy and health care and the internet and the environment, is going to have to somehow absorb this extensive investigation, which means that we won't be able to do the other things that we've done. I mean, I've been the ranking member since January. We've done the doc fix. We've done 21st century cures. We've done legislation on the internet, on toxic waste. We've done so many things on a bipartisan basis, because we came here before these things went to the floor. And now we are going to waste scarce resources on an investigation that has already taken place and revealed absolutely nothing. It's not even clear to me, based on what Ms. Blackburn said, that the other committees cannot continue their investigations. She suggested that that's all going to be incorporated in this select committee, but it's not clear to me that the other committees aren't going to continue their investigations at the same time. And I'm just telling you, we have so many things to do here that are important that have not been looked at. This has been looked at. No laws have been broken. Nothing has been indicated in any way that anyone has done anything wrong here by Planned Parenthood or anybody else involved in the things that Ms. Blackburn mentioned. So why are we wasting our time with this special committee? Now, I went to, I'll say this last thing. I don't want to take up too much of your time. I went to a Planned Parenthood site in my own district this morning, and I heard women talk about the health care services that were being delivered there. It was just, I guess, Breast Cancer Month, Awareness Month last month. Now in October is Ovarian Cancer Awareness. Maybe I got them switched. Maybe one was 1 month and I got the month switched. But they're all there working on doing screenings, doing diagnosis, all these things that are so important to women. And to rake them through the coals once again, after they've had all this they've had to do to show up and produce papers, all of which have shown nothing at all, particularly for the poor women. This was in Perth Amboy, which is a city that I represent, has a lot of poor people, a lot of Medicaid people. We've had already hearings in the committee, in the health subcommittee, and in the full committee to bring bills to the floor to defund Planned Parenthood and other organizations from their Medicaid. I mean, this committee has not only done the investigation, but has brought legislation to the floor that addresses a lot of the things that Ms. Blackburn is mentioning. I see absolutely no reason for this, absolutely none whatsoever. And it pains me to think that we're just going to spend even another day, let alone another 2 months or another 3 months, wasting members' time and resources of this Congress on something that has already been done. So I'm begging you, I don't know, maybe I sound more like a bureaucrat than anything else. I'm not trying to take away from the seriousness of the issue. But I really think that this is just a waste of time and resources, creating another bureaucracy with this panel that's not necessary. And, you know, I understand that it's a serious thing for all of you, but there's no reason to do it this way, even if you think that we need to continue an investigation. Why are we setting up a select committee to do it? It's not necessary, Mr. Chairman.
Ms. Plone, thank you very much for your testimony. Ms. Blackburn, thank you very much. I appreciate you being here. The gentlewoman, Mrs. Fox, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, it's disappointing to see some of our colleagues continually resist our efforts to ensure the House exercises one of its most fundamental constitutional responsibilities, oversight of the use of federal funds. There's been a lot of discussion here today about Benghazi. That's an entirely separate debate. Whatever one's position on the events surrounding the attack there, the Select Committee formed to investigate it, we can all agree that Congress maintains a responsibility to investigate other unrelated issues. Consistent with that responsibility, we're here today to ensure that an organization that receives hundreds of millions of taxpayer dollars a year is not breaking federal law in its sale of the hearts of unborn children. There are also credible allegations that children may have been born alive and left to die in order to harvest their tissue. How can Congress ignore that? If these abortion providers somehow manage to comply with all federal laws while dismembering children, it's clear that Congress needs to amend those laws, and a full investigation is clearly the only way to proceed. Our colleagues in the minority certainly believed in the past that certain issues deserve serious investigation or additional study. When in the majority, Democrats formed the Select Intelligence Oversight Panel under the Appropriations Committee, as well as a Select Committee on Energy Independence and Global Warming. The creation of a select investigative panel on the issues surrounding the sale of unborn children's tissue is clearly within precedent, and I hope members on both sides of the aisle will agree that we must get to the bottom of this through a full investigation. Only then can Americans be confident that their taxpayer dollars are being used appropriately by organizations in compliance with federal law and basic human rights. With that, I yield back, Mr. Chairman.
Thank you very much. Mrs. Slaughter?
Oh, thank you. I do have a few questions, but let me first talk about the Select Committee as part of the appropriations. One difference was subpoena power. There was no power. As far as I know, this is the first time a Select Committee, a subcommittee, basically, has gotten subpoena power, and it only goes to you, right, Mrs. Blackburn? Only you will have it.
It will go to the chair of the select committee.
And that will be
the
you.
The speaker will make those appointments.
All right, well, all right, whoever the speaker, or whoever the chair is, this committee will have sole discretion over subpoena, which is unusual.
Well, when you read, you also see that and as Mr. Pallone knows, we have had a record and a history of working in a bipartisan manner at Energy and Commerce, and he just mentioned that. He also, when you read this and you look at the designation of powers in the construction of the legislation, the chair of the select panel, upon consideration with the ranking minority member, may order the taking of depositions under oath and pursuant to notice or subpoena by a member of the select panel or a council of the select panel. Mm-hmm. So right there, you have the consideration and consultation that is built in to the language of this.
Mr. Plum, do you agree with that?
I'm not sure that,
very unusual.
I'm not sure that the language gives much authority to the ranking member.
No,
but-
I think what it says is the chair of the committee may do it.
Right. But I also
And
think.
probably will.
I also
Well,
think.
let me retain
Sure.
my time a minute, because I know everybody's got someplace else they've got to go. Will this new committee suspend the ongoing investigations of the House Oversight and Government Reform Committee?
Ms. Slaughter, the intent is to bring all the work on the issue, the 6 issues that are designated in this language, to bring that under one umbrella. To bring them together, it will be the investigative panel of the Committee of Energy and Commerce. The thought is that this will be a more expedient way to handle this, a more efficient way, and will allow us to make a determination as to laws, if there was any law broken,
Okay.
or if there's any need for further investigation.
I'm not exactly clear on that that's an answer to the question. You bring
I think
everything
it's a
under
pretty
one
good
umbrella.
answer.
Well, what I need to know, let me be very specific here. We need to know if the ongoing investigations that are going on, the House Oversight and Government Reform Committees, the Energy and Commerce Oversight Committee, which is, I gather, that's still ongoing, is it not, Paul? And the House Judiciary Committee are all going to be on this select committee? Is that what you're telling me?
I am telling you that the intent is to centralize with the select panel the investigations from the 3 committees that have been mentioned: Energy and Commerce, Judiciary, and Oversight and Investigations. Those investigations will be brought under one umbrella.
How much will it cost?
The budget is being worked on by the Speaker's office, and I'm not privy to any numbers. I do know the Speaker
Do
is
you know
working
when we'll
on that.
get, is this going to be set up this week?
This is the call of the Speaker.
Well, it would be nice if we have at least an estimate on what tax money they intend to expend on this. Are you going to be looking into anything else but Planned Parenthood? You going after any other groups or?
Planned Parenthood isn't mentioned in this at all.
Okay, well, it isn't? That's
ma'am.
not your purpose, is Planned Parenthood?
Planned
the way you-
Parenthood is not designated in this at all.
Well,
We're
I don't
looking
care
at
if it's
the
listed or
practices.
not. Is that your intent? We can all,
The intent is the 6 provisions that are designated.
you know, it really sounds to me like you've got a lot of new powers. I think you could go on a lot of fishing expeditions, and the unilateral subpoena authority really is troubling, I think. And there's no coordination required for anything else. We don't even know how this committee is going to be set up. Why is it going beyond normal regulations set these up? Why is this one singled out and to be different and will subsume the rights of 3 other committees, as I understand you to say, and give unilateral subpoena power? What's the, do you have some reason to believe that this is going to benefit the intellectual knowledge of the United States of America?
Absolutely.
You do.
I certainly believe it is going to benefit
We're
the
going to keep
knowledge
trying for the
and
rest of your life,
information.
aren't you?
I think it's going to benefit the knowledge and the information, and it's imperative that we look at what is happening with the money that is being appropriated.
Well, what I want to know is what's being done with the money that you're appropriating for yourself. And obviously, that's not a question that we're going to be able to answer today. But as I mentioned earlier, we spent $5 million on Benghazi. That's just the one select committee. We had 3 other committees, I believe, that investigated Benghazi. And 2, I remember, that came to conclusion. Armed Services and Intelligence, led up by 2 wonderful Republicans, said there's nothing there. But if you won't take no for an answer for time in eternity, I think it's an awful waste of federal resources. I know it's a waste of people's tax money. And I would almost tell you right now, you're going to come up with the same thing that everybody knows all along, that all that money is spent for health care, and that the abortion money is entirely separate because a lot of us contribute to it. I have no further questions.
Gentlewoman has no further questions. The gentleman from Oklahoma, Chairman Cole's recognized.
Thank you very much, Mr. Chairman. I won't take a lot of time. I know we don't have a lot of time. First, I want to welcome both my friends, here, particularly my classmate, Ms. Blackburn, but Ms. Malone, it's always great to have you up here. You're always a terrific witness, and it's nice that we so often see you, as you alluded in your own comments, up here in a bipartisan way. There are lots of areas on energy and commerce where we found common ground this year, and you guys would be commended. I just want to make this quick observation on this. Look, it's clearly a very emotional issue to all concerned, and I think many people, not just quote on my side of the aisle, but I think millions of Americans were deeply disturbed by what they saw in those videos. I just think they were. And they want to know, is this a practice that somehow their federal tax dollars are in? I chair the Labor, Health and Human Services and Education Subcommittee on Approach. And, most of this money that finances, Planned Parenthood or other organizations, because we don't just finance them. It's done in grants. We don't appropriate to them at all, but you're talking roughly $300 million in a better than $70 billion budget at Health and Human Services. And I will just tell you, from a practical standpoint of administering a hearing, this takes a lot of time because the emotions are so high. So I actually welcome the investigation and the committee, because I think it will actually help us do what we're supposed to do in the Appropriations Committee in a much more knowledgeable light. And I don't know how you do it other than actually, put a searchlight on it and go after it. Absent that, let's just let the chips fall where they may. We may find out. I certainly give you time to respond. We may find out. Matter of fact, I'm certain we'll find out things that at least my committee is not knowledgeable about, and where they disagree. I think they would just appreciate the additional emphasis and focus, so we can get around to looking at other parts of Health and Human Services. We try to do that. We have a lot of hearings this year, but this one inevitably takes up an awful lot of time. Disproportionate given the amount of money involved, but not disproportionate given the importance of the issue and the intensity that people feel about it. So if it can be approached the right way, maybe we can actually resolve some of our concerns. With that, I certainly yield time.
Well, I just wanted to say, my concern listening to Ms. Blackburn and then contrasting it to what you said, Mr. Cole, is that, you mentioned the videos, and that was what started this investigation in Energy and Commerce and the other committees. And, I think we conclusively showed that these videos were edited or doctored or whatever, so they're not accurate, okay? What's concerning me today is that if I listen to Ms. Blackburn, she seems to be moving beyond, the issue of the videos and whether Planned Parenthood did anything wrong, and is now talking about a much larger investigation into abortion and the issue of abortion. And that's really unfortunate, because, the fact of the matter is that the right to abortion exists, according to the Supreme Court. As Ms. Slaughter said, there's no funding of abortions with federal dollars. So now this seems to be very much a fishing expedition that's going way beyond Planned Parenthood.
Well, I would interpret it a little differently, and I certainly will let my friend speak for herself, but I see this much more about fetal body parts than I do about the issue of abortion. And I think there's, frankly, a lot of, tricky areas here in terms of what are the appropriate practices, what should you do? And I'm not sure that any single committee with scattered jurisdiction and here and there can ever bring a focus. It's clearly something that is causing a great deal of angst in the country. And I think people would, by and large, feel better if they knew there was a laser-like focus from somebody. Obviously, on Energy and Commerce, you have broad jurisdiction. You're dealing with a lot of different things. Other committees, my committee has some jurisdiction here in terms of the discretionary funding, but I'm not sure it's ever going to get the attention that it merits absent the Select Committee.
Well, I'm just really concerned after listening to Ms. Blackburn, but now we're not just talking about whether somebody violated the law with Planned Parenthood. We're now talking about the larger issue of abortion and whether or not we should be allowing abortion, whether we should be allowing research into with fetal tissue. This now really is beginning to sound like a fishing expedition to me, and I think it's very unfortunate. But I'll
You haven't raised your question. I want to give the gentlelady from Tennessee an opportunity to respond.
Well, Mr. Chairman, you said it very well. I outlined the 6 components of the bill, and you pointed to the business practices area, which is the primary focus. We do know that the Planned Parenthood affiliates, many have had programs, and other abortion providers have had programs where they move the fetal parts out for donation. Now, the 93 NIH law prohibits any profit from that. But as we look at the procurement organizations, we know that we have 2 entities that are for-profit and 1 that is not for-profit. So to look at those business structures, yes, sir, that's going to take the time to move a little deeper and to look at those business structures. You're exactly right on that. And then the federal funding component, also to look at the provisions that are there for a child that survives an attempted abortion. We have all met individuals that have grown up and had wonderfully productive lives and survived an attempted abortion. And then also the care that facilities are required to give to those children when they do survive those abortions. So those are components that we will look at. The 6 are listed. There is, I don't know where you think there's going to be this going into other abortion issues. I think that it's fairly tightly drawn.
Well, I just want to, frankly, I know this is a very emotional, highly charged subject. I just want to commend both of you, frankly, for your demeanor and your manner and your professionalism. And, you know, where you've disagreed, you disagree in a very professional way, and we'll see where it goes. But I have a high degree of confidence in the members of the you know, Energy and Commerce Committee, the manner in which they do things, because they do so many things and have done, you know, so many things in recent months in a bipartisan way. So I think this will be approached the right way, and I think we'll find out some things that maybe will help us all understand what, if any, changes we need to make to current law and what, if any, abuses have occurred. And it might put some things to rest. We may find some common ground out of this instead of just division. That would be my hope anyway as we go forward. Thank you very much, Mr. Chairman. I yield back.
Gentleman, you're back. It's time, gentleman, Massachusetts.
Well, thank you, Mr. Chairman. And if we're trying to find common ground, this is a lousy way to do it. This select committee is the worst possible way to try to have an intelligent discussion about this issue. Let's be honest, this is not about a process to make people feel like we're getting answers. You've had committee hearing after committee hearing after committee hearing, and we've let the chips fall where they may, and the chips have fallen in a way that says that, you know, Planned Parenthood hasn't done anything wrong, that they're a good organization. Now, the problem is my Republican friends don't like the answer, that their own committees are coming to conclude, and so what they do is they want more hearings, and they still can't get the answers they want, so now we're going to have special select committees. And we're not going to talk about how much we're going to spend on it. That's something that will be determined in the future. It's up to the Speaker. Millions and millions of dollars on yet another witch hunt against Planned Parenthood. I think this is why people can't stand Congress, because they're trying to figure out, like, why aren't we talking about how do we keep the government running? Because we're going to run out. We have another deadline on December 11th when we're going to have to figure out what we're going to do next. They're frustrated that we're not talking about jobs or about how their kids can afford a college education or about the environment or about anything that matters in their lives. And we're going down this pathway of yet another, you know, special select committee that really, I think this legislation was probably written in the Republican Congressional Campaign Committee. This is not serious. This is we should be ashamed of spending our time right now pushing this kind of approach to this issue. We shouldn't legitimize this process. This is not the way we should be going. You know, you've done the hearings. You know, everybody gave their speeches. They all had their press conferences. Let's move on. And instead, you know, it's like the ranking member said. It's like the Benghazi committee. I mean, all these committees that have come to the conclusion that there's nothing there. And, you know, you don't like the answer. It doesn't satisfy the right-wing base, so more hearings, select committees, more money being spent, more energy being wasted. I mean, we got to do our jobs up here. And I have to tell you, it is so frustrating to sit here and to go through this exercise. And I know that if anybody who's paying attention, I hope nobody is paying attention to what we're doing in this committee. But if they are, I mean, people have to be wondering, like, this is what we elect members of Congress to do, to come and play these political games? I mean, I get it. There's a number of my Republican colleagues who, want to overturn Roe versus Wade. You want to make abortion illegal under all circumstances, including in instances of rape and incest. I get it. But, then vote that way and move on. But to waste Congress's time doing this, another witch hunt against Planned Parenthood, I mean, and I love this, even this discussion here lacks clarity, because we're told on one hand that Planned Parenthood isn't mentioned, and that yet everybody here is talking about Planned Parenthood. So we all know what this is all about. And I think it's just it's a terrible waste of resources, time, and energy. And again, it reinforces the notion that so many people, Democrats, Republicans, and independents have about this place, and that is that this institution doesn't work. It's broken. And this is not a serious place. And this is not a serious initiative, and I yield back my time.
Gentleman yields back his time. The gentleman from Texas, Dr. Michael Burgess.
Thank you, Mr. Chairman, and I thank my ranking member and thank Ms. Blackburn, the Vice Chairman of the full Committee of Energy and Commerce, for being here. Ms. Blackburn, this is not your first experience with the Select Committee, is it? Were you not part of the Global Warming Special Select Committee on Global Warming?
You are correct. I was one of the designees to that select committee.
And since the question has been asked, do you remember how much money that select committee spent?
I remember that one trip spent well over $1 million. It was to Copenhagen to the UN Climate Summit.
And I must have missed the report that the Special Select Committee delivered to the Congress?
There was never a concurrence of opinion. The witnesses that came before us, some of those who had supported the IPCC report favoring global warming, then subsequently began to remove their signature to portions of that report. And it also became apparent that instead of moving in a trajectory that was consistent with a global warming trend, that the Earth had begun to cool, and that the cooling had begun to take place in, I think it's 97. And the cooling is continuing even as we speak. Therefore, the terminology shifted from being global warming to moving toward the concept of climate change.
Yeah, and be all that as it may, it just underscores the point that if it is important to the Speaker of the House, as it was then important to Speaker Pelosi,
correct.
it is within their purview and prerogative to designate a special select committee. And I appreciate your service on that committee then, because I know that was must have been a significant sacrifice. Let me ask you this, because generally an oversight committee like our Committee of Oversight and Investigations in Energy and Commerce typically is not a legislative committee. Will your special select committee be making recommendations to the Committee on Energy and Commerce and the Judiciary Committee? You mentioned perhaps there are some changes in the procurement laws governing fetal tissues and the extraction of fetal tissues. There may be necessary to be some fundamental change in law. Would your committee be making that recommendation or doing legislation?
We will conduct our findings, issue our report, which will include our recommendations, and then look forward to disbanding the committee.
And it would be up to the committees of jurisdiction
That is
to follow through with legislation.
That is correct.
Mr. Chairman, I know we have a vote on the floor. I'm going to reserve further questions for later in the process, but thank you, and I'll yield back I'm sorry, did the ranking member want to respond?
No, you didn't. You're fine. I don't agree with you, but I have nothing to add.
Let the record show that the ranking member was in complete agreement with my statement.
Complete disagreement, but nothing to add.
Thank you, Mr. Chairman. Well, a lot of us, of course, thought the Benghazi Committee was going to be designed to look into the incidents in Benghazi. We later found out from the majority leader that it was designed to reduce Hillary Clinton's poll numbers. How can we have any confidence that this committee isn't used for overtly political purposes? I mean, Ms. Clinton is also a supporter of Planned Parenthood. She's a pro-choice. I'm a supporter of Planned Parenthood and pro-choice. I mean, how do we know that this committee isn't going to go after Ms. Clinton like the Benghazi committee? Yeah, Mr. Pallone.
Well, I don't know if I'm exactly answering your question, but I am very concerned that this is all ideologically based. You know, if that's the same as political or partisan, fine. I mean, we had a hearing or a markup last week, and you know, one of the members, I don't have to mention who, said, well, you know, this is an ideological debate. You know, suggestion that, you know, this is a Republican said, well, in my district, people are against abortion, and so you have to expect that I'm going to be in favor of defunding Planned Parenthood or not allowing Planned Parenthood to have, you know, to receive Medicaid funding. And my response to that was, well, again, it shouldn't be ideological. I mean, just because you disagree that we shouldn't have abortions doesn't mean that you should close down Planned Parenthood, because abortion is allowed under the law. The Supreme Court has said you have a right to an abortion. And so that's why I'm concerned, not only that it becomes partisan and political, but as Ms. Blackburn says, it's even going beyond that. The way she reads this thing, it sounds to me like we're going to investigate whether we should even be having abortions, whether or not we should be able to do research on fetal tissue. I mean, you have to understand, these things are basic rights. These things are important fetal tissue research to science.
And
what are we doing here? We have this ideological political battle over things that I thought had been resolved by the courts and by science. And to pursue this, you know, your best statement you said, Ms. Slaughter, was a fishing expedition. The more Ms. Blackburn reads this thing, the more I'm concerned this is just a fishing expedition to do anything. It's like Mr. Cole said, well, we'll see what happens. Well, I don't want to take away from what he said, but it was almost like, well, we'll set it up, we'll see what happens here. Well, I mean, is that how we operate here in Congress?
And I just worry that since we found out that the reason for the Benghazi was to reduce certain presidential candidates' poll numbers, that there might be some similar goal of this committee. I strongly support Ms. Slaughter's amendment now that we know what the Benghazi committee's for. I think that's an inappropriate activity of Congress, so I mean, we need to end that. I hope that this one doesn't go the same way. But Mr. Pallone, even if your committee wanted to look into this, couldn't they just schedule a hearing and do it as opposed to having a whole different?
Look,
yeah.
I think it's quite clear, based on what she said, that Mr. Chavez said, it is quite clear that the initial purpose of looking to see whether Planned Parenthood did anything wrong or did anything illegal is over, okay? That has been thoroughly investigated. We issued a report saying, based on everything that we've seen so far, this was a Democratic report by the committee, that there is nothing here that they have done wrong, and Mr. Chavez essentially agreed with that. So now I think what's happening is they're going beyond that. They're saying, well, maybe they didn't do anything wrong, but we still need to look into this whole issue of what's going on with abortions, what's going on with fetal tissue.
And perhaps what's going on with Hillary Clinton. I mean, we saw what happened with Benghazi, right?
Here. And so it has now become a fishing expedition that seems to even go beyond the issue of whether Planned Parenthood did anything wrong.
Well, the gentleman from Colorado yield just for 1 second.
I'll be happy to, sure.
Thank you very much. I appreciate that. Just since I was quoted.
No, I don't mean to misquote.
Well, I think you did.
It bothers me.
Well, let me finish my point.
All right.
I didn't say, let's just see what's happened, and I didn't imply anything. I said there's a great deal of controversy here, and I think an investigation might clear it up, and we might actually understand the issue. So please, when you quote me accurately.
All right, I don't mean that.
I can go back and have
The
it read
concern
out.
I have, though, Mr. Cole, is that you started out by talking about the videos. I don't think there's any question that the videos are not accurate as any kind of evidence, all right? And so my fear is that we are moving beyond the issue of the videos and whether Planned Parenthood
Well,
did anything
all I
wrong.
said, that's one of the things that raised this to great concern, and I think it did. Now,
gonna
there's other
wanna-
questions related to that. All I would ask, if you're going to quote me, I'm right here, and if I didn't express myself clearly, just say, maybe you want to clarify something, I'm happy to do it.
I don't mean to suggest you're saying that you should do anything.
Again, I'm pretty careful about quoting.
Yeah, and I'm not suggesting, you're a great guy, and I'm not suggesting that you say that we'll just see what happens. I don't want to suggest that you just think, you know, they can do whatever they want. I mean, clearly, she has indicated certain items they're going to look into. But I am concerned, yeah, you were very explicit. But I am concerned, if I could just finish, that the issue of whether Planned Parenthood did anything wrong, or even the issue of Planned Parenthood, is now kind of being, well, we did that already. Now let's look at what else we need to look at.
Again, I understand your concerns, I would just
concerns
ask
me.
you not.
Let me reclaim my, if I can reclaim my, let me reclaim
Yield
my
back
time.
to my-
Thank you. I think, yeah. Thank you, Mr. Chairman. And I'll talk about my amendment later, but I'm doing an amendment to provide transparency as to the costs of this committee if it moves forward. I think it's common sense. It's monthly reporting to the chair and ranking member with the cost information for the select panel for the preceding month. Hopefully that won't be controversial and we'll adopt it. And I'll talk about that when we talk about our amendments. And the lady from New York wanted me to yield to her, so I'm happy to yield to the ranking member.
Just for a minute, I think the most important here is not whether we're going to find something or we're not. What is really wrong here with what we're doing with both Benghazi and with this one is we're using the power of the House of Representatives, the committee process, and the taxpayers' money to make political points. That, ladies and gentlemen, is what's wrong here.
I'm happy to yield back.
Thank you, Mr. Chairman. I'm so glad to sit here and watch the Democrats never make political points. But I do have a question for the gentlelady from Tennessee. You know, I understand the frustration on the other side, but what I'm trying to understand is why everybody would be scared of subpoena power. When you subpoena somebody, can they say things that aren't true?
Mr. Stivers, the point of issuing a subpoena, and Dr. Burgess mentioned the select committee that we did with the previous speaker, Ms. Pelosi, and she would utilize subpoena power for some of those. So if the chairman of the committee decides that there needs to be a subpoena issued, then they'll have the ability to move forward with that so that through depositions and through subpoenas, we can get to the bottom of these issues and get some clarity and some answers for the American people. It is taxpayer dollars, and they deserve to know how those dollars are being spent. They also deserve to know if laws have been broken. And my colleague mentioned the report the Democrat committee had done on Planned Parenthood. May I, for the record, make certain that everyone realizes that was a report that was provided to the committee by the Democrat staff. It was not a project of the Energy and Commerce Committee. It was a project of the Democrat side, and it was not something that was a comprehensive or conclusive look.
And how many hours of hearings do you know that the Energy and Commerce Committee has had to have on this topic so far? Can you guess? 8 hours, 10 hours, 50 hours, 100 hours?
Pardon me. I know during the month of August, our O&I staff and Health Committee staff worked diligently to begin to compile the information that was necessary to move forward. I think in committee we have had a total of 4 hours of hearings on this specific issue since the footage went into the mainstream. Prior to that, Mr. Stivers, we've been looking at the issue of federal funds, taxpayer dollars, abortion, abortion laws and regulations. Those things are something that is a constant oversight issue of the committee, as it should be. It's a part of the jurisdiction.
So since the time of the videos coming out, Mr. Plone, you feel comfortable? 4 hours is plenty of time. We've thoroughly investigated this with 4 hours of testimony in committee.
I mean, understand that the purpose of the O&I investigation, and I understand also the purpose of the Select Committee, is not primarily to have hearings, but to do an investigation. So countless hours were spent with the investigation. The fact that they only had certain hearings, I don't know how many hearings this committee would, Select Committee would have as well. The purpose is primarily to spend the time investigating, not to have hearings per se.
Fair point, and I think that's an important clarification, and I want to get to the truth, and that's the point, and that's why we need this subcommittee, and I think anybody that's scared of subpoenas is just scared of the truth, so I yield back the balance of my time.
Thank you very much. I'd like to notify the panel as well as our members that we are on a vote. There are probably about 40 members that have not voted. Probably a number of those members are in here. I'm sorry we did not get through with everybody. I'm going to ask that our two witnesses come back after the second vote. And I'd like to ask that you come back. Yes, thank you. We will now recess subject immediately after the second vote. Committee will come to order, and thank you very much for coming back immediately after votes. Mr. Polis, did you finish all of the questions that you had?
I did. Thank you, Mr. Chairman.
Thank you very much. I'd next like to go to the gentleman from Alabama.
Thank you, Mr. Chairman. Mr. Plone, I may have misunderstood what you said, and I certainly don't want to mischaracterize what you said, but I think I understood you to say you did not think that the tapes were evidence of anything. Did I misunderstand you?
Well, the tapes, the evidence shows that the tapes were doctored, you know, spliced, you know, cut up, whatever you want to say. So I don't think there's any question that they can't be the basis for any kind of allegations or condemnation of Planned Parenthood, because there's no accuracy to them because of the way they've been doctored.
Have you seen the unedited tapes?
Well, that came up at one of our hearings where, you know, in response to my saying this at the hearings last week in the committee, some of the members said, well, you have to look at the unedited tapes. But then I went back and I was told that those have been edited, so they're not really unedited.
Well, I have seen the unedited tapes. And I think any fair-minded person who watched the unedited tapes would agree that they are indeed evidence of bartering over the prices for the sale of fetal body parts. And
Well,
I'm not finished with what I was saying, sir. I'd be happy to let you respond, but let me finish saying what I was going to say. The purpose of the committee is to take that piece of evidence, and I know that you're a lawyer and you understand what evidence is, and all of us understand the practice law. You take one piece of evidence, it can lead to other things. And certainly a special committee could look into that evidence and see where it takes us, and it could take us to a number of things that I think it's important for Congress to know, not whether it's Planned Parenthood or anybody. Do we have people in the United States of America who are harvesting baby body parts and are selling them on a market where people barter over price? Now, whether you or I agree about abortion doesn't matter. That's not what the point at all. You could be completely pro-choice and yet be fundamentally opposed to the harvesting and sale of baby body parts. I have friends that feel that way. So I do think it's an appropriate thing for Congress to do. I do think it's an appropriate thing for a committee of Congress to do. I haven't been here long enough to know about whether you need special committees or this committee or not, but I think it's a very relevant area of inquiry for us to follow through on. And just to dismiss the tapes out of hand, I think would be a mistake. I think we have an obligation to follow up on it, because it is a question of what's appropriate for us to allow, whether federal funding is being used or not. But particularly if federal funding is being used, we should know that, and we should take appropriate steps, in my judgment, to stop it. So I do think it's evidence, and I would ask you to go back and look at the tapes, and they are unedited, and draw your own conclusion after you've done that, as we all should. But I hope you would also agree that it merits our following up on to find out what else is out there. But I'll let you respond to that.
Let me just say that I completely disagree with you in terms of the value of the tapes. I don't think there's any question in my mind that that the conclusion can be drawn that the tapes have no evidentiary value. And that's why I think, because they've been doctored, you know, the so-called unaltered ones are not unaltered. The bottom line is, I think that what's happening here, and this is my own opinion, you don't have to agree with me, is that very quickly in the last few weeks, the Republican mantra has moved away from the tapes and whether Planned Parenthood did anything wrong, which has not been shown, and now is moving to other things. You know, the larger issue, as Ms. Blackburn said, about, you know, abortion, the use of fetal tissue. You know, in the last few weeks, the debate in the committee and on the floor was on a bill that would allow states to take away Medicare funding from any institution that either performed abortions or referred abortions. And as Ms. Blackburn said, no reference even to Planned Parenthood. Just the fact that an organization was performing abortions or a hospital was referring people for abortions was now the basis for defunding or not allowing Medicaid funding to be used. So I have to disagree with you. I think that the GOP has moved away from these allegations about Planned Parenthood doing anything wrong to these larger issues now, which I think Ms. Slaughter said is a fishing expedition that maybe isn't even related necessarily to Planned Parenthood, but just because you just think that ideologically we shouldn't have abortions, or we shouldn't allow abortions, or we shouldn't allow fetal tissue to be used for research. I know you don't agree with me, but I think that's what's happening here, and that is in some ways bothering me even more so than the issue of that was originally here about the tapes. I don't hear anybody telling me anymore that we can use the tapes as a basis for saying that Planned Parenthood did anything wrong. I haven't heard that in you know, at least a week or two now. That seems to be old hat.
Well, claiming my time back, we do disagree with one another, because I think that the tapes are evidence from which a congressional panel could go to get other information that are important to understand. And I've never spoken about this issue in partisan terms, because I don't consider it to be partisan. Now, you've brought up partisanship several times in your comments. I'm beginning to wonder why the Democrats are so afraid of an inquiry following up on what's clear evidence that something was happening. There was some sort of bartering going on there. You don't, if you're only going to charge for the cost of something, you're not talking about the price. The cost is the cost is the cost.
Let me ask you this,
So I haven't given up my time, sir. That the truth of the matter is that this shouldn't be partisan. And I would hope that Democrats would want to get to the truth like we would. But the more I've listened to the discussion today, I'm beginning to wonder that the Democrats are worried about where this may lead. This may actually go somewhere that the Democrats don't want to go. So I think this is a very legitimate use of congressional resources based upon my viewing of the tapes and my discussion with a lot of people about what they've seen in the tapes. As lawyers had to use tapes before in court, I can tell you they very well could be used as evidence in court, would be used in court. I can tell you they'd be admissible in court. And so I think it's a legitimate thing for this Congress to do. I know that you and I disagree, and that's fine, but I don't think this is a partisan thing. I hope you would think again about your comments in that regard, because I don't view it as a partisan. I view it as an appropriate function of Congress. And having said that, Mr. Chairman, I yield back the balance of my time.
Mr. Chairman.
Thank you very much. Excuse me just a moment, sir. Thank you very much. Gentleman yields back his time. Do any of our witnesses have further short comments that they'd like to make?
Mr. Chairman.
The gentlewoman's recognized.
Thank you, Mr. Chairman. I would just like to provide Mr. Pallone some assurance. He has alluded to the fact that I said things that maybe I may not have said. So I want to be sure we're clear on the record. The legislation defines very clearly the 6 areas where this committee is going to be spending their time and the areas that they're going to look at.
Excuse me just a moment. Mr. Pallone, have you been provided with the information that she is talking about prior to this hearing today? Thank you very much. Gentlewoman's recognized. Thank you very much. Gentlewoman's recognized.
It really is quite explicit, Mr. Chairman, and so I want to be certain that he has that knowledge and that information. The other thing I think it's important to say, they continue to say, well, the Democrats have already done an investigation. I would reiterate that was an investigation by their staff committee at Energy and Commerce. It was a report of the Democrat staff. It did not delve into the issues, and it was not conclusive in its findings. So therefore, it is not something that we would see as a tool to use in the research and the work into delving into these issues and making certain that we get the appropriate answers for the taxpayers. And with that, I yield back.
Thank you very much, Ms. Blackburn. The gentleman from New Jersey, do you
Mr.
seek
Chairman,
time?
let me be clear.
Does gentleman seek time?
Yes.
The gentleman's recognized.
Thank you, Mr. Chairman. The O&I subcommittee did the investigation over the last couple of months on a bipartisan basis. In other words, everything that went on in terms of the investigation was bipartisan. The Democrats, at the end of that investigation, you know, a few weeks ago, based on the information that had been provided on a bipartisan basis, issued a report saying that there was no evidence that Planned Parenthood did anything wrong or did anything illegal. That was partisan, the conclusion that we came to, but it was based on the bipartisan investigation. Now, the one thing I did want to point out to Mr. Byrne, and this will be my last comment, the concern that I had was that, and I think, you know, he said that I should be concerned about where this went and, you know, making any conclusions. I think that the Republicans should be concerned about the fact that the Center for Medical Progress that did these videos, which I say are not of evidentiary value because they've been altered, They are now being investigated by various groups. I don't know whether, I don't think our committee really did any thorough investigation of them because they were just presumed innocent. I think if I were you, I'd be concerned about the fact that this group did these videos, altered these videos, and is now, the head of it is now taking the Fifth Amendment and refusing to testify. That's what I would be concerned about. But look, and I don't want to keep going on with this. I think my point is clear that this subcommittee, regardless of how you feel, in my opinion, is not necessary because if you wanted to, you could just continue with the investigation of the O&I committee. I think this is just a complete waste of time and creating a new bureaucracy totally contrary to what you, as the GOP, preach. You say you don't want to waste taxpayer dollars. Why are we setting up a new bureaucracy for this, a new subcommittee? It's not necessary. Thank you, Mr. Chairman.
Mr. Pallone, thank you very much. I want to thank both you and Ms. Blackburn for not only your hours up here before this committee trying to answer questions to give us clear answers and clear responses, but I want to thank you for your commitment to the things which you believe in best. And I want you to know that we will take to heart not only this testimony, but also the information. We look forward to you coming back anytime in the future. You both did well enough to get invited back, and I hope you'll do that, and thank you very much. This now closes the hearing portion of establishing a select investigating panel of the Committee on Energy and Commerce Committee, and the chairman will now be in receipt of a motion. The chair will accept a motion from the gentleman from Oklahoma, Mr. Cole.
Mr. Chairman, I move that the committee report the resolution to establish a select investigative panel of the Committee on Energy and Commerce, the House, with a favorable recommendation.
We now have heard the motion from the gentleman from Oklahoma, the gentleman Chairman Cole. Without objection, the resolution will be considered as read and open for amendment. Is there any discussion or amendment?
Yes, Mr. Chairman.
Gentlewoman from New York is recognized.
Thank you. I'd like to offer amendment number 1. While the majority stated purpose was to supposedly get to the bottom of what happened in Benghazi on September 11th, 2012, it's clear the majority's used the Select Committee on Benghazi to politicize a tragedy. Speaker in waiting Kevin McCarthy accidentally told the truth last week and admitted that the Benghazi Select Committee had one mission alone: to influence a presidential election. Using official resources for campaign purposes is a clear violation of the rules of the House and federal law, and is a clear and undeniable abuse of official staff time, resources, and attention. It undermines the work of the House and misleads the American public. Representative McCarthy's statements make it clear that the majority uses select committees for politics, not for governance, and we must put an end to that abuse. Mr. Chairman, my amendment would strike the Planned Parenthood Select Panel, replace it with a resolution which would abolish the Benghazi Select Committee to ensure that the House's work is kept in appropriate bounds. And since all of us are bound by the same ethical standards when we become members of the House of Representatives, I hope that we will get a yes vote on this amendment.
Further discussion? I'd like to reply that I appreciate the gentlewoman and her ability to comprehend as she sees the things which have been in the press and makes an amendment. But I'd like for her to know that as the member of this committee, as chairman of this committee, as a member of this body, I have noticed the work, attention, detail, and professional nature that Mr. Gowdy, Trey Gowdy from South Carolina, who served as the chairman of this select committee on Benghazi, has not only conducted himself, I believe, in a most professional, ethical, and honest manner, but has pursued the matter with official resources of the federal government, including the Federal Bureau of Investigation, the FBI, and the Department of Justice. I believe that there are serious questions which have properly been raised. I believe Mr. Gowdy has not publicly misused any part of his official duties and has conducted himself, as well as the committee, in the highest of ethical provisions that we believed when we established the committee could be achieved by Mr. Gowdy and each of the committee members. I believe that the minority and the majority have presented professional, honest, legitimate people to participate in the committee. And a characterization by a member of this body, as we all can do, to make characterizations about the work that is performed, they can be held accountable for. But the actual work, the product, the nature, the detail, and the professionalism that this committee, select committee, is doing, I believe has brought honor and respect, and that the American people will see that their report was professionally done, focuses on the facts, and settles itself therein. Is there any other discussion anybody'd like to have? Seeing none, the vote will now be on this Slaughter amendment. Those in favor signify by saying aye. Aye. Those opposed, no. No. Noes have it, noes have it. Gentlewoman asks for a roll call vote.
Ms. Fox. Mr. Cole.
No.
Mr. Cole, no. Mr. Woodall. No. Mr. Woodall, no. Mr. Burgess. No. Mr. Burgess, no. Mr. Stivers. No. Mr. Stivers, no. Mr. Collins. No. Mr. Collins, no. Mr. Byrne. No. Mr. Byrne, no. Mr. Newhouse. Ms. Slaughter.
Aye.
Ms. Slaughter, aye. Mr. McGovern. Mr. Hastings. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
2 yeas, 7 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion. Gentleman from Colorado.
Thank you, Mr. Chairman. I have an amendment to desk, amendment number 2, which I would like to make a motion to have in order. My amendment, Mr. Chairman, is a simple one that would require transparency with regard to the costs of this. We had a little bit of an exchange about where the money would be coming from. Obviously, as custodians of taxpayer money, I think it's important that we have the information that's in my amendment, namely the amount of expenditures of the select panel, where the money is coming from, are there any other areas of the committee that are being curtailed or funds being diverted. I've heard that funds from some slush fund might be diverted to this select committee. I don't know if that's the same slush fund that was used to try to prevent me from getting married, and I think that cost over $1 million. Fortunately, it failed. But I think that we all want to know where that money is coming from, since we are the custodians of taxpayer money. And my amendment would simply require the Energy and Commerce Committee to issue a monthly report detailing the subcommittee's expenditures, talk about how and where funds are coming from, and if they're coming from non-energy and commerce accounts as well, which would mean detracting from the rest of the work of the committee. And I'm hoping that this committee will include this amendment. I yield back.
Thank you very much. Further discussion. I'd like to let you know that related to the expense reporting processes, these are all very good points that the gentleman makes. The Speaker of the House, committee chairman, including anyone that is selected, including the chairwoman of House Administration, and certainly myself as chairman of the Rules Committee, chairman of the Energy and Commerce Committee, the gentleman from Michigan, Mr. Upton, will be concerned about the money that is spent, the effectiveness of the committee, and the outcome.
But I suggest, Mr. Chair, that they don't spend $1 million going to Copenhagen.
Excuse me just a moment, please. The Energy and Commerce Committee will be able to coordinate with House Administration Committee to ensure that it has the necessary resources. That means that I would anticipate that as we move through with this, that the Speaker would select a subcommittee chairman, a select committee chairman. That select committee chairman would put together those things that would be necessary resources to go to the House Administration. Secondly, all committees, including select panels, are subject to monthly reporting requirements today, which are available on the Committee on House Administration's website. Expenditures are listed in the statements of disbursement. So that information is already being processed. It is part of the rule and would be done. And this amendment adds burdensome reporting, which is not required of any other House committee. So we believe we're trying to cover that, gentlemen.
So are you saying that the expenditures of this committee will be reported as a line item, so other members of the House can see?
It is my understanding that it will be reported, the expenses on a monthly basis that are trackable.
And will it be up to this speaker or the next speaker where those funds come from?
It would be from the House Administration.
It comes out of the House Administration.
House Administration. If there were additional resources necessary, that would be done with the House Administration.
Okay, and I think it's clear there'd be some resources. I mean, just convening a committee and.
Yes, sir.
I don't know whether they're going to travel or not, but I mean.
Yes, sir. So what I'm trying to suggest to the gentleman is we've tried to make sure, we've been thoughtfully represented tonight that we are concerned about the taxpayer dollar. The Republican Party, the Republican majority is concerned about taxpayer dollars, effective use of that, and we're trying to show that in our expense reporting and transparency requirements.
Okay, I thank the gentleman.
Does the gentleman wish to move his amendment?
Yes.
Those, we will now, through the discussion, we'll now move forward on the from the vote on the amendment from the gentleman from Colorado. Those in favor of the post amendment, signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Roll call vote, Mr.
Gentleman asks for a roll call vote.
Ms. Fox, Mr. Cole. No. Mr. Cole, no. Mr. Woodall. No. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Stivers. No. Mr. Stivers, no. Mr. Collins. No. Mr. Collins, no. Mr. Byrne. No. Mr. Byrne, no. Mr. Newhouse. No. Mr. Newhouse, no. Ms. Slaughter. Aye. Ms. Slaughter, aye. Mr. McGovern. Mr. Hastings. Mr. Polis. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman,
Clerk
no.
report the total.
2 yeas, 8 nays.
Amendment's not agreed to, not agreed to. Further amendment or discussion? Seeing none, the gentlewoman is recognized.
I thank you. It's not an amendment, but I just would like to make something clear. I've heard my colleagues on your side of the aisle claim that somehow there's a precedent for this highly partisan select panel, and I want to address that issue. That's not true. The select panel and its powers are clearly unprecedented, and this resolution creating it should trouble everyone here concerned with the integrity of the House of Representatives. Republicans claim that House Resolution 35 from 2007 is the model for this resolution. That resolution from 8 years ago created a select intelligence oversight panel of the Committee on Appropriations. But that resolution and the select panel were different in every important way. A, the resolution gives the chair of the new Planned Parenthood Select Panel the extraordinary and unprecedented power to unilaterally subpoena any American she or he wishes and to force them to testify at a hearing. B, the Select Intelligence Panel from 2007 had no subpoena authority. On the contrary, the resolution creating that intelligence panel did the exact opposite of what today's resolution does. The 2007 resolution explicitly removed the limited subpoena authority that all normal subcommittees have. Instead, the authority was vested in the full Appropriations Committee. C, in fact, no subcommittee chairman in the history of the House has ever received unilateral subpoena power before. D, this resolution also grants the new subcommittee chairman the authority to force private citizens to spend tens or hundreds of thousands of dollars hiring attorneys to sit with them during lengthy partisan interviews by Republican staff and lawyers. E, the 2007 Select Panel had no staff deposition authority. This effort to create yet another partisan select committee is an abuse of the process and is entirely without precedent. And Mr. Chairman, I ask unanimous consent to enter into the record House Resolution 35 of the 110th Congress, clearly showing that the so-called precedent that you are citing for this partisan effort today is nothing of the sort. Thank you, Mr. Chairman.
Further discussion about the Slaughter Amendment? I'm sorry, did you make a motion?
No.
You just read a statement. I want to thank you very much. I would say to the gentlewoman and to the members of this committee that every single member of this body is entitled to their own opinion and a discussion of the facts themselves and with their constituents back home. I would like this body to understand that I have been inundated and I have received feedback from others who believe it is a very important issue, a legal issue, a moral issue, and a question that needs to be resolved. I have attempted to work with our leadership on an effective way that would allow a select group of people who would look at the facts on a bipartisan basis and report back. I believe that this is an honest, diligent way for us to answer the question so that we can, under the authority and responsibility that all of us have as members of Congress, representing people, to be able to go back with a report that we did not personally do, but that was done by a special group of people who looked at the facts of the case. My personal opinion, just me, I am looking for this committee, select committee, to do exactly that. And I would like to assure every member of this committee, Republicans and Democrats, that in no way did I believe that anything that I have done here as chairman, nor led this committee to, including the discussions about the formation to the committees, about their intent, about their resolve, and about the honesty that they would forthrightly accomplish. I did not believe that Mr. Gowdy would do anything wrong, and I still believe today that he has of the highest ethical, moral, and responsibility to the duties of his office has done. I do not know who the Speaker of the House will select to lead this committee, but it is my intent to have a discussion on a private basis about this same type of intent, professional conduct, and moving forward to the facts of the case as it relates to this. I think Mrs. Slaughter is entitled to her opinion. I think I am entitled to mine, and I think you are too. And I want to thank you for being here today for this important hearing and for the processes that are taking place. So at this time, we will now go to a final vote on the Cole motion. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it. The ayes have it. So without objection, the committee staff is authorized to make technical and conforming changes to the resolution. The motion passes. A Cole motion passes, and the gentlewoman, Mrs. Fox, will handle as a privileged resolution.
And I will handle it for you.
And Mrs. Slaughter will stand for the Democrats. Okay, so we now have a manager, Mrs. Fox, for the select panel for H.R. 3192, the homeowner. We are now going to go to a motion from the gentleman from Oklahoma, the gentleman, Chairman Cole. Gentleman's recognized.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant H.R. 3192, the Home Buyers Assistance Act, the closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides one motion to recommit. Section 2 of the rule provides that on any legislative day during the period from October 12, 2015 through October 19, 2015, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. Finally, Section 3 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 2.
Now heard the motion from the gentleman from Oklahoma. Is there amendment or discussion? The gentlewoman from New York is recognized.
Thank you, Mr.
Yes,
Chairman. We have yet another closed rule. So I've got an amendment to the rule. I move the committee grant H.R. 3192 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Thank you very much. Further discussion. Vote will now be on Slaughter amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Roll call.
Gentlewoman asks for a roll call vote.
Ms. Fox. Mr. Cole.
No.
Mr. Cole, no. Mr. Woodall. No. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Stivers. Mr. Stivers, no. Mr. Collins. Mr. Collins, no. Mr. Byrne. Mr. Byrne, no. Mr. Newhouse. Mr. Newhouse, no. Ms. Slaughter.
Aye.
Ms. Slaughter, aye. Mr. McGovern. Mr. Hastings. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
2 yeas, 8 nays.
The motion is, the amendment is not agreed to. Further amendment or discussion. Gentleman from Colorado.
Mr. Speaker, I'd like to submit for the record a statement of administration policy with regard to the Homebuyers Assistance Act.
Without objection, we'll do that. Thank you very much. Okay, the vote will now be on the Cole amendment. Those in favor, motion. Those in favor for the Cole motion, please signify by saying aye. Those opposed, no. No. The ayes have it. The ayes have it. And accordingly, the gentleman from Ohio, Mr. Stivers, will be handling this. Mr. Poles will be handling this for the Democrats. I'd like to let us know that the next meeting will be tomorrow at 3.
I beg your pardon,
Excuse me just a moment, please. Mr. McGovern. We'll get that right. Thank you very much, Mr. McGovern. Tomorrow, we will have a meeting at 3 o'clock on the two
Mr.
energy
Chair,
bills.
let the record show I'm always happy to do my duty when called upon.
Yes, sir. I want to thank everybody for being here tonight. Our awesome stenographer, we appreciate her being here very much. We're now finished our work for the day.